the National Highway Traffic and Safety Administration Manual.
Is it a lawsuit? Probably. Why not?
Well, hello everybody, and welcome back to Buckle Up, It's the Law. Folks, today we are going to do something special. We are going to be talking about a area of the law that is very prevalent, not just in the Karen Reed case, but is prevalent in the Kohberger case, in the Johnny Depp versus Amber Heard case, Masterson, trial number 1 and trial number 2, Weinstein, trial number 1 and trial number 2, the Diddy case, Adelson case, the Welch case, all cases, the Sarah Boone case, you name it, it is in every single one of those cases, and then some. And that is the sometimes known as the motion for preservation of evidence, but sometimes it is simply known as don't destroy evidence. You see, some people may or may not know this. It is a crime. It is a felony to tamper with physical evidence. It's a felony in Kentucky, where I practice, and it's a felony in probably every single state in the union. What am I talking about? So typically, in an everyday basis, can you delete your text messages? I'll give you a few seconds to respond. Well, sure you can. Of course you can delete text messages. Now, same question. What about your call log? Or your GPS history, or your Facebook history, or your Facebook timeline, your voicemails, your DMs on X or Instagram? Can you delete any of those things? Answer, absolutely. There is nothing on this planet that inhibits your ability to delete things that you have control over, things that belong to you, things that are yours, things that are under your possession. Now, if they were obviously someone else's property, you would not have the ability to destroy them, at least from a legal perspective. However, what happens if you are sued? Or what happens if you're called in to testify as a witness in a trial? Can you then have carte blanche to destroy whatever you want whenever you want it? Answer, no. Even without a subpoena or without what's known as a motion for preservation of evidence, i.e. do not delete, destroy, etc., this piece right here, when you are sued, there is a presumption that there is going to be evidence that is going to be used against you. So for instance, in a personal injury case, if there is evidence that you have gone skiing 2 months after your wreck and you're claiming that you were not able to walk 3 months after the accident, your ski trip and any photos that you have taken of you skiing 2 months after the accident is very inculpatory evidence. It is evidence going against the fact that you were injured in your accident. So if your lawyer were to tell you, hey buddy, I'm not telling you to do this, but you might want to delete this evidence on your Facebook page because that is really going to put a cramp in our style and our ability to recover money for you. So how about you just get rid of that evidence and make sure that the judge and the jury and the plaintiff's attorney or whatever, the defense attorney, never get a hold of it. Well, folks, that is a crime. Not only is it a crime, it is probably almost certainly going to be grounds for disbarment. And there have been cases out there where lawyers have told their clients openly, delete XYZ, and have gotten in some serious trouble for it. Back when Facebook was still in its, I don't want to say inception stages, but definitely infancy in the first few years, there was a lot of question about what lawyers can and cannot tell their clients to do. And then a very famous case, I believe from 2013, there was a lawyer who was actually sanctioned by a court for $500,000, which was the bulk of the fee that the lawyer earned from a case where a jury awarded multiple millions of dollars to a client. It has been found since the verdict was rendered that the lawyer advised the client to, quote, clean up their timeline, end quote. The lawyer advised the client to delete without preservation potential evidence that could have been used against their client in the case. And that is very dangerous because, again, you are now becoming a witness to your own client's case. Not only are you telling them to destroy evidence, you are also telling them to commit a crime, thereby being complicit to that crime. So when you are the subject of litigation, if you are the plaintiff or the defendant or a witness or the client themselves, it is never a good idea, number one, for a lawyer to advise their client to destroy evidence, nor is it advisable for you yourself without listening to or talking to anyone to destroy evidence. I mean, look at the Karen Reed case, for example. We had evidence that all of these people, Matthew McCabe, Jennifer McCabe, Brian Albert, Colin Albert, Allie McCabe, and Brian Higgins, at the very least, all 6 of these, the big players, the real conspirators, co-conspirators to the murder of John O'Keefe, they all destroyed the evidence right before it was ripe for the picking, right before the defense filed their motions, right before the judge issued an order. They had to shift the timeline to pretend like it all happened before. The reality is it all happened after. They were just trying to cover it up to make sure that nobody gets the real evidence of what happened that fateful night. So you as a lawyer, as an advocate, should never tell your client to clean up their Facebook, as this lawyer had to pay $500,000 just to buy their way out of it, essentially. That was the fee, the penalty that they had to pay for giving their clients advice on how to commit a crime. Oh, and you, as the client or the potential defendant or even the plaintiff, never, ever should destroy or delete evidence because, once again, it could be used against you. In a very, very famous way, when there is the absence of evidence, there's something known as a missing evidence instruction that could go in the jury instructions in your jury trial to the jury that is going to be deciding your case. The missing evidence instruction, as a matter of fact, is going to allow the jury to extrapolate. They are going to be permitted to believe in the jury instructions by the judge. We'll read it to them. It will state something along the lines of, you are to presume that if this evidence had been in existence, it would have been detrimental to that party. Basically, it would have been either exculpatory or inculpatory, depending on who you are. So for instance, as a criminal defense attorney, I could have a missing evidence instruction that the police officer had a body camera on and it is missing and they can't find it. I can say, well, it will be presumed to the jury that that evidence would have exonerated my client. It would have been good stuff on there going against the police and for my client. Or in a civil case, let's say if you are the defendant who is saying, well, the plaintiff deleted their Facebook account, I, the defense, in the civil case can say, well, we can presume that had this Facebook page still been in existence, it would have damaged the plaintiff's case and helped me, the defendant, and so on and so forth. So folks, don't delete evidence. Don't forget to subscribe to the video, subscribe to the channel, like this video, etc. And don't delete evidence. It's just not a good idea. It's a terrible idea. And if you need real legal advice, call us. 1-844-774-HURT, 1-844-774-HURT. We are standing by 24 hours a day, 7 days a week to answer your legal questions. That's it for me. I hope you all enjoyed this. I hope you all learned something, and I will see you all in the next video. Bye, everybody.